Good evening. The German philosopher Gottfried Wilhelm Leibniz developed a theory according to which we are living in the best of all possible worlds. After the two lectures last week, I wondered whether our lecturer is a follower of Leibniz and whether we are living in the best of all possible constitutional worlds already. Everything seems to be in a robust equilibrium, notwithstanding some tensions and frictions. Today, the judiciary will be the topic. For centuries, the judiciary was the least controversial of our powers, the chief guarantor of the rule of law. Today, we witness most astonishing criticism and attacks on the judiciary, on individual judges, specific judgments. No holds barred, no quarter given. The shock that came from the first headline, "Enemies of the People," is it wearing off already? The lectures are about the UK Constitution. In other jurisdictions, we see a similar, even more troubling chipping away of judicial independence. We see judiciaries so politicized that plaintiffs worry more about whose judge they will get, my side or your side, rather than about the merits of their case. These developments abroad concern us too. Extremists, enemies of the rule of law, embolden each other across borders. I apologize for opening the evening on a gloomy note. I am confident, however, that the lecture will provide us with resources of hope. The floor is yours, Lord.
And thank you again for coming to listen to the third of these lectures. Maitland wrote to Dicey, "The only direct utility of legal history lies in the lesson that each generation has an enormous power of shaping its own law. Legitimacy is the foundation of the authority of the state and of its institutions. The primary object of a state is to maintain legitimacy as regards its citizens, and an object of the institutions which comprise the state is to maintain legitimacy in the eyes of each other. In a complex and changing world, there is no simple or single recipe for this. Legitimacy has various sources, and their force and the balance between them is susceptible to change. In this lecture, I will seek to explain how the courts exercise constitutional agency in both the senses I have been using that term. They have a certain level of discretion allowed them by the Constitution when articulating and applying the law. What they do in interpreting the law also has a reflexive effect on the form of the Constitution itself. The court's primary function is to identify and apply the law, which seems to indicate an absence of agency. But the courts develop the law interstitially through the processes of interpretation and application. In interpreting and applying legislation, they exercise a degree of partnership with the legislature. This is a form of agency, albeit one which is constrained. In developing the common law, they similarly exercise a form of agency, in that case constrained by established common law principles. The agency which the courts exercise is both constrained and diffuse. It is constrained because the courts operate to apply established rules and principles, and this limits their scope for action. Their agency is mediated through the principles they apply. They operate within a constitutional tradition and subject to legal constraints. Their agency takes the form of a power to develop that tradition incrementally from within. They do not have the sort of wide powers of decision available under the Constitution to the executive and to Parliament. Application of legal norms is a constant process which can arise in the courts at any time, and this distinguishes it from legislative action, where the focus is on a specific act at a particular time to define new laws to govern in the future. The judicial application of an already existing norm binds together past, present, and future in a way that a legislative act does not. A judge has to understand how the norm to be applied came to exist in the past and its meaning then, and decide what meaning it should bear in the present to govern the dispute before the court, and, potentially, what meaning it should carry into the future to be derived from the precedential value of the decision. The agency exercised by the courts is diffuse, in that it only arises when cases come before them for decision, and because there are many courts making many decisions within the framework of the constitutional tradition. Change tends to occur slowly and rather indirectly. Courts react to the cases before them. Legal reasoning is practical reasoning to deal with particular problems which present themselves on the facts. There may be a groundswell of decisions at the lower levels of the court system, responding to particular circumstances and perceived problems as they are presented in individual cases. Then, at the highest level, a particular change in the direction of travel may be endorsed by the apex court and encapsulated in a new authoritative statement of principle. There are three tempos of time in a democracy embedded in a common law constitution. There is the need for an elected government which can respond at speed to events in the world as they unfold. This is executive time. It is characterized by a high level of discretion and flexibility for maneuver within very broad legal parameters. There is essentially an unavoidable need for a high level of discretion in order to govern. A political order needs the capacity to react and react quickly to unpredictable changes in circumstances. Then there is the need for the elected legislature to be able to make considered proposals for reform of the law and to make decisions in light of what is judged to be the needs of the day. This is legislative time. It proceeds from public debate, from which matters of public concern emerge through refinement by application of democratic procedures, that is, voting in elections on the basis of party manifestos, adoption of legislative proposals for presentation to Parliament, into enactment by Parliament as concrete laws. And finally, there is the need for basic ground rules to be worked out to provide the framework for democratic contestation and engagement. This is the dimension of constitutional time. In the dimension of constitutional time, one can speak of long waves of constitutional principle in the common law. There are foundational rules which are particularly firmly embedded in the operation of the governance system, so that it makes sense to speak of them as constitutional, as distinct from ordinary rules of statute or the common law. As well as the courts exercising their own agency, the doctrines developed by them enhance the types of agency exercised by the other branches. In relation to the executive, on the one hand, by requiring legality, fairness, and rationality when it acts, the courts uphold standards of decision-making which respect underlying constitutional values and enhance the legitimacy of that action. By doing this, the courts help the Constitution as a whole meet Bernard Williams' basic legitimation demand. There is a well-known history of the development of the law of judicial review, which shows the courts responding to changes in the nature of the state and the role of the executive, and framing legal doctrine in the light of these. On the other hand, through the development of more explicit norms in relation to the separation of powers, the courts have mapped out areas where the executive is entitled to particular respect for its judgments about how to proceed. In this way, they support the effectiveness of executive action, which makes another important contribution to the acceptability of the constitutional order. In relation to Parliament, through application of the fundamental principle of parliamentary sovereignty and an approach to statutory interpretation, which essentially rests upon identifying the purpose and meaning chosen by Parliament, the courts give effect to governance through democratic decision. At the same time, through application of the principle of legality in relation to the interpretation of legislation, the courts have identified a series of fundamental constitutional principles and rights, which are treated as especially embedded and as having special status within the constitutional order, so that there is a presumption that Parliament does not intend to override them. Since the articulation of legal doctrine is the province of the courts, the development of these features of statutory interpretation represents the exercise of a form of agency by the courts as well. Particularly in relation to the principle of legality, the courts have an important role in identifying, distilling, and articulating the applicable constitutional principles and rights. The courts are in this way the primary interpreters of the Constitution. They also have a major role in deciding in a determinate way how the fundamental balance is to be struck between the constitutional pillars of the rule of law, including protection of individual rights, and parliamentary sovereignty. Maintaining this balance in a stable way across time is a central constitutional function. The principle of legality has a narrow application and is not applicable as an approach to statutory construction in the absence of a relevant established fundamental right or legal principle. In the Lightfoot case, Mr. Justice Laws warned that if the courts were to hold that more marginal claims of right should enjoy the protection of a rigorous rule of statutory construction, not applied in contexts save that of the protection of fundamental rights and freedoms, they would impermissibly confine the powers of the elected legislature. This statement has been endorsed at the highest level in the case of O and the Secretary of State for the Home Department. By treating the principle of legality with caution and keeping it within narrow bounds, the courts have made a choice to protect the general constitutional principle of democratic choice, subject only to limited presumptive constitutional constraints. Respect for democratic legitimacy imposes an obligation on the courts to try to be clear-eyed about what background understandings really are so commonly and powerfully held as to inform statutory interpretation in this way by application of the principle of legality. Otherwise, they may put their own legitimacy as decision makers in jeopardy in the eyes of the public. This discipline has forced the courts to engage in reasoning drawing on our constitutional traditions to identify the constitutional rights or principles which require special recognition and protection in this way, using those traditions as a source of legitimate objective standards of judgment to which the courts can make appeal when justifying their decisions. Parliament has exercised its own constitutional agency by laying down a general framework for the exercise by the courts of their agency. By enactment of the Human Rights Act, Parliament has given the courts an equivalent role in the interpretation of legislation under Section 3 to that which they have when interpreting in accordance with the principle of legality. Under Section 6, it has also given the courts an enhanced role in subjecting executive action to judicial review. In both cases, this has been done by setting out a table of rights to be respected by reference to those in the European Convention. Under this regime, the courts have the role of identifying and applying the Convention rights, essentially through a process of translating them from the jurisprudence of the European Court of Human Rights in Strasbourg. In this area, again, the courts are on the front line in striking the fundamental constitutional balance between protection of individual rights and democracy, that is, between the principles of individual autonomy and of collective self-government. Two features of that jurisprudence are particularly important in domestic constitutional terms: the margin of appreciation and an implicit sense of an appropriate allocation of powers between executive, legislature, and courts in a liberal democratic state. Through the criteria which govern the ambit of the margin of appreciation, the courts incentivize debate in Parliament and so incentivize the proper functioning of a deliberative democratic order, thereby enhancing the agency of Parliament. They also reflect the point made previously about plural values in society and the need for resolution through the democratic process. Dréon and France provides a good example of a lower level intensity of application of the proportionality doctrine in respect of convention rights in the face of recognized social disagreement and democratic resolution. The Strasbourg court recognized that, I quote, the national authorities have direct democratic legitimation and are in principle better placed than an international court to evaluate local needs and conditions. In matters of general policy, on which opinions within a democratic society may reasonably differ widely, the role of the domestic policymaker should be given special weight. End quote. In Animal Defenders International and the United Kingdom, the Strasbourg Court attached considerable weight to the consideration of its case law in both the parliamentary process and the national courts as to how to strike the correct balance for Article 10 purposes in the regulation of broadcasting. This feature of the deliberation in the domestic political and legislative system led the court to afford the state a widened margin of appreciation, which is to say, a widened ambit in which it would be prepared to accept the exercise of legislative choice as compatible with the convention rights. It was significant that the case concerned a general measure in relation to which the court had to assess the legislative choices available, where the quality of the parliamentary and judicial review of the necessity of the measure is of particular importance, including to the operation of the relevant margin of appreciation. This may make the processes of human rights scrutiny in Parliament, for instance, via the Joint Committee on Human Rights, particularly important, and can be regarded as a form of incentive for the legislature to deliberate by taking the convention rights into account when legislating. Given that the central task for the Constitution is to produce a stable balance between individual rights and the democratic principle, it is highly desirable that the law incentivizes Parliament in this way to seek to strike that balance itself by having explicit regard to the individual rights and interests at stake. As part of the principle of legality, legislation is to be construed in the light of values recognized under the common law and which it is presumed the legislature also recognizes. Thus, where legislation confers a discretionary power to take action against an individual, there is a presumption that the power must be exercised fairly. What fairness requires depends on the context in which the power arises and the circumstances in which it falls to be exercised. The open-textured nature of the fairness standard which is implied into legislation means that the courts have an active role to identify what fairness requires in any given case. The rationality standard applied by the courts is also flexible and subject to modification depending on the particular context. The requirement that a public authority should act rationally when exercising a discretionary power is a general rule of public law, but it applies in many different contexts, and the ambit of what qualifies as rational may require to be adjusted in the light of what the law recognizes as particularly weighty factors which fall to be considered in a particular context. This has been identified as the position where an individual's human rights are an issue, where anxious scrutiny of a decision which interferes with those rights may be called for. The leading cases are ex parte Bugdeke and ex parte Smith. The more substantial the interference with human rights, the more the court will require by way of justification before it will be satisfied that the decision falls within the range of decisions which are rationally open to the public authority within the parameters of its discretion. In certain contexts, other values may be recognized in law as being of similar significance and weight, so as to lead to a similar approach to the application of the rationality rule and a corresponding narrowing of the lawful parameters of the relevant discretionary power. That is the position in relation to the principle that democratic engagement by councillors at the local government level should be promoted and not undermined, discussed in a case called Armstrong-Braun. Again, a form of anxious scrutiny was applied. So the courts identify and give effect to underlying constitutional rights and principles under the rubric of rationality review, as well as under the rubric of the principle of legality. Broadly speaking, where the principle of legality applies, a statutory provision cast in general terms may be wholly inapplicable. There is a bright line barrier which prevents the executive from taking action. But even if the principle of legality does not apply, so there is lawful scope for the executive to act, constitutional values may still apply to modify the application of the rationality standard. This doctrinal position allows the courts to reflect a balance between constitutional rights and decision-making by democratically accountable organs in a more modulated way. The flexible nature of the concept of rationality in English public law is well recognized, but perhaps not always well theorized. How can there be a spectrum of different levels of rationality reflecting different intensities of judicial scrutiny? I suggest that the answer to the conundrum of a flexible rationality standard lies in the density or otherwise of common background constitutional understandings which form the context in which the administrative decision in question falls to be considered. Where it is the exercise of a statutory power which is in issue, the primary source of the relevant background understandings will be the statutory scheme in which the power is embedded. However, even in that situation, there will be scope for argument by reference to other background understandings not set out or directly reflected in the statute itself, but nonetheless capable of informing the rationality context in respect of that power. A rationality approach based on referring to the density of common background understandings offers the advantages that, first, it allows the courts to spell out and articulate the underlying factors which drive the ebb and flow of intensity of review under the rationality heading, thereby promoting greater transparency and predictability of response. And secondly, it allows scope for integrating in a more coherent and satisfactory way the judicial review standards to be applied in highly varied statutory contexts, and also in relation to the Crown's prerogative and common law powers. There should be a common focus on identifying the criteria according to which rationality of a measure may be assessed. There is a range of sources which inform judicial and public opinion, and which together are capable of generating background understandings, which may come to be widely shared so as to have strong normative force within what Jack Balkin calls a spectrum of plausibility about constitutional legal claims. He says, reasonableness is not a single set of correct views. Rather, it is a distribution of possible positions about which reasonable people might differ, bounded by other views that are off the wall. The boundaries of the reasonable and the unreasonable, which people use to judge legitimacy, are produced in social life, including through politics. However, if the courts wish to use these understandings to inform the principle of legality or rationality review, there is an onus on them to spell out what they are and the evidence for them. So fundamental principles and rights are treated as embedded in the Constitution. These are what Maitland called points of high principle. By virtue of their embedded nature, they form part of the presumptive constitutional order which Parliament is taken to respect, subject to its ability to override them by use of very clear language. Under the rationality standard, they form part of the presumptive constitutional order which the executive is obliged to take into account when deciding how to act. The court's role is to identify what principles and rights exist, the degree to which they are fundamental, and how, in practical terms, they are to be reconciled with the democratic principle as it applies both at the legislative level and at the level of executive action. Each level of this analysis involves the form of agency on the part of the courts which I have described. The courts move beyond a faithful agent model of their role, if that is to be taken, I would say, implausibly, to require them simply to apply legislation construed purely in terms of linguistic meaning. The function of identifying rights and principles derived from disparate materials is itself an activity involving a form of agency. The courts have to decide if additional normative content has to be injected into the statute or the governing law. But the process is one of recognition and deduction from evidence rather than invention. Still, this means that the courts are partners in the constitutional order, not purely passive agents. The role of the courts has fluctuated over time in response to shifts in the nature of the state and corresponding shifts in the balance between Dicey's three pillars of the Constitution: the sovereignty of Parliament, the rule of law, and convention. I will highlight 7 developments and then consider the 2 Miller cases. The underlying theme is how the courts have reacted to the expansion of the role of the state and of the power of the executive, combined with a sense that political controls via convention and political morality were becoming attenuated and inadequate for the protection of important rights. First, by the early 20th century, even Dicey was prepared to admit the need for the development of a new administrative law to control executive action, something which had been notably absent from his account in his Law of the Constitution. In 1915, he wrote about how administrative law was developing, noting the application of new standards of administrative fairness to be applied by the courts against a background where ministerial responsibility subject to political scrutiny was not perceived to be an adequate safeguard. Second, there was the major revival and development of judicial review doctrine in the 1960s, exemplified by the trilogy of Ridge and Baldwin, in which emphasis was given to the obligation of fairness in the exercise of executive power, Padfield, in which emphasis was given to the obligation to use statutory powers for proper purposes, and Annis-Minnick, in which interpretation of a statute was carried on in the light of the principle of access to justice. These are regarded as landmark decisions because they signaled a significant shift in the way in which the courts would approach the interpretation of powers in statute. As Lord Hodge has said, the development of administrative law in the second half of the 20th century has indeed been a major legal development, as the incremental application and development of pre-existing principles in changed circumstances and in response to developing social needs. The changing social need to which legal doctrine responded was the greatly increased role of government and other executive bodies in the lives of citizens in the course of the 20th century. Lord Hodge also suggests that changing social attitudes played a part, a decline in respect for and deference to established public institutions, and the rise of a more questioning attitude in society and a greater awareness of, or tendency to think in terms of, individual rights. As Martin Laughlin points out, the positivization of the basic rights of citizens has the potential to reconfigure the architecture of public law. A coherent approach to administrative law was developed to reflect standards of good administration in the interests of citizens as they came to be recognized by the courts. The historical context for this is well described, I think, by Joseph Jacob in The Republican Crown. He recounts the public disquiet about the Critchell Down affair in 1954, involving high-handed treatment of landowners by civil servants, leading to the Franks Committee inquiry into administrative tribunals and inquiries of 1955 to 1957. Third, in the 1970s, there was renewed concern about the effectiveness of control of executive power through norms of political morality. Neville Johnson, in his 1977 book, In Search of the Constitution, identified the erosion of 19th century style political morality under the pressures of modern politics and modern government, and made the case that the rights of the individual should be restated and safeguarded, both those which are intended to protect him against the abuse of authority, and those which establish his status as a citizen and from which his political obligations stem. He argued that this would restore authority to the UK's pattern of representative government, whilst at the same time maintaining its respect for liberty under the law. There was then a long period of single-party rule by the Conservatives from 1979. The domination of Parliament by one party in this way served again to call in question the effectiveness of political controls in relation to executive power. Senior judges like Lord Scarman and Lord Bingham called for greater legal controls and the incorporation of the European Convention into domestic law. In the 1980s, the concept of anxious scrutiny review was identified. In the 1990s, in cases such as Pearson, the principle of legality was identified and given renewed force and prominence. In this way, the courts gave legal effect to a range of individual rights identified by them with increasing specificity. In broad terms, this was justified by the courts on the basis that Parliament is taken to legislate for a liberal democracy in a constitutional state which observes the rule of law. However, if such broad concepts are regarded as capable of injecting determinate content into a statutory rule, the scope for the law to be affected by changes in the understanding of these concepts across time, as identified by the courts, is clear. Fourth, in 1998, the new Labour government passed the Human Rights Act to enhance legal enforcement of fundamental rights. Labour did this, having had the experience being out of power for some 18 years, which made it very conscious of the weakness of political controls in relation to executive power. In a work of 2004, Neville Johnson argued, quote, "In recent times, deference has largely collapsed and the very notion of elite rule is widely rejected. It follows that there are few social and moral resources available in the society to impede the steady withering away of the customary practices by which the Constitution itself has been extensively defined. We have, therefore, to face the fact that a customary constitution might in some circumstances require resort to an injection of the kind of explicit principles thought to be characteristic of codified constitutions if it is to survive." End quote. This perspective supports the general contribution of the Human Rights Act to the current constitutional settlement. Fifth, from the 1960s onwards, there was a gradual extension of judicial review of the exercise of prerogative and common law powers of the Crown. This has followed an arc from ex parte Lane in 1967 through recognition in the GCHQ case of the possibility of judicial control on the basis of underlying principles, which one could describe as fundamental or constitutional, to the quashing of the prorogation of Parliament in the second Miller case. The result in the latter case was justified explicitly in terms of the requirements of principles fundamental to a polity having the character of a parliamentary democracy, namely to ensure that Parliament should be able to carry out its constitutional functions as legislature and as the body responsible for supervision of the executive. Sixth, the doctrine of legitimate expectations also developed in the late 20th century, as the courts gave legal protection to procedural and substantive legitimate expectations based on policies or assurances given by public authorities as to how they would exercise discretionary powers. The underlying justification for this development was increasingly put in terms of constitutional principle. At first, emphasis was given to the abuse of power, which was said would occur if there was a change of policy in circumstances where a person had relied upon it to their detriment. But this had to be balanced against the constitutional responsibilities of the authority in question. Later, a distinct justification was given based on a constitutional principle of equality of treatment and protection against capricious and unjustified differentiation between persons falling within the scope of the policy. This has the effect that detrimental reliance is not required. The result is that legal force is given to the internal controls exercised by the executive over itself, as described in my first lecture. In substance, the courts have recognized the constitutional importance of this form of control over executive power. Seventh, the courts have increasingly analyzed the balance to be struck between the role of the executive, parliament, and themselves in terms of the separation of powers. The courts have to explain, carve out, and delimit their role versus that of other agencies of the state. Separation of powers tend to be the framework in which they seek to do this. Separation of powers has gone up the legal agenda and it has also become more finely tuned over the last 60 years or so. This is partly a result of the widening application of a principle of functional specialization and responsibility in the public sector and the ever greater functional differentiation of the concept of the Crown standing for the executive. A conception of specialized zones of policymaking by different agencies of the state has developed, and the courts have had to define where the boundaries are and then police them. This means the courts have had to address the boundary between law and politics, but also that between courts using legal expertise and specialist policymakers using other forms of expertise. On both boundaries, the Diceian concept of the rule of law as one set of rules for all has come under pressure, to be replaced by the concept of the rule of law as appropriate demarcation to secure what Sir Jack Beatson calls the balance of responsibilities. The connection between the rule of law and the separation of powers is thus made central. Contrary to the Diceian conception of the rule of law, the courts have recognized a specialized domain of public law. The application of human rights under the Human Rights Act and the principle of legality, and the proportionality standard of review associated with those rights and with the doctrine of legitimate expectation arising from government statements of policy, have drawn courts more into the realm of specification of policy. This has meant that the courts have had to articulate with greater care and specificity the proper limits of their role as against other agencies. By doing this, the courts seek to defend a zone of law distinct from politics and policy, which are recognised as properly being the subject of political contestation or specialist evaluation. Witness the Alconbury case, for example, and the SC decision. Section 3 of the Human Rights Act has given the courts an enhanced interpretative role, which is quasi-legislative. So the courts have had to explain how far they can go in modifying the meaning of legislation so as not to undermine the essence of the legislature's role. Public law has increasingly come to be concerned with functional specialization, and the response of the courts to this, in the light of underlying constitutional principles of the rule of law and democracy, for which parliamentary sovereignty stands as a cipher. Both have implications for the separation of powers, as a series of Supreme Court judgments illustrates. In Majera, the court emphasized the obligation of the executive to obey a court order. In SC, the court emphasized the width of the margin of appreciation for Parliament on matters of economic and social policy. In Shamima Begum, following the Raymond decision, the court emphasized the responsibility of the executive for judgments about national security on grounds of both democratic accountability and expertise. In Privacy International, the court divided, where there was a collision between different aspects of these principles. All these shifts in doctrine exemplify exercise of constitutional agency by the courts. The aim has been to maintain an underlying constitutional balance between the roles of the executive, Parliament, and the courts across time, under circumstances where the balance between the pillars of the Constitution described by Dicey has come under pressure and has changed. The requirement that the executive and legislature respect constitutional norms means that the Constitution slows down the tempo of executive time and legislative time, and so has a calming effect, one hopes, on politics. That aids legitimacy as well, and reinforces loser consent. It gives reassurance that minority views have been considered and not lost in the rush to get things done. The liberal democratic system can only function effectively if respect for it, and consequently for the laws it produces, is maintained across time. I'm not so much a devotee of Leibniz, but I now have a quote from Hegel. Hegel observed, "How blind they are who may hope that institutions, constitutions, laws, which no longer correspond to human manners, needs, and opinions, from which the spirit has flown, can subsist any longer, or that forms in which intellect and feeling now take no interest are powerful enough to be any longer the bond of a nation." So against this background, I turn to examine the two Miller cases. Miller 1 concerned the giving of notice under Article 50 of the Treaty on the European Union for the UK to leave the EU. In conceptual terms, this is not a difficult case. It concerned the interpretation of a statute, the European Communities Act 1972. Had Parliament left it open to the executive to neutralise the effect of that act by unilateral withdrawal from the EU by giving notice without parliamentary authorisation? Both the Divisional Court and the Supreme Court held that it had not. One can debate the result, but the task to be carried out and the methodology to be applied were straightforward. Miller 2 was more difficult. It concerned the lawfulness of the prorogation of Parliament during the Brexit crisis concerning the negotiation of the terms of withdrawal with the EU. The power of prorogation is a matter for the prerogative, not statute. So the courts had to address the issue in the context of the less developed law concerning the prerogative and the control of its exercise in modern times. The case stands in the line of development of public law over the past 70 years, which I have mapped out. The argument for the government was that the exercise of this prerogative power was non-justiciable because of the political context and the availability of political control through standards of political morality and the theoretical power of MPs to vote down the government on a confidence motion. But these claims had to be assessed in the light of the erosion of customary standards of political behaviour over decades and a general loss of confidence in them. They also had to be assessed in terms of what was at stake and in terms of how directly implicated and at risk were recognised fundamental features of the Constitution in terms of parliamentary sovereignty and the role of Parliament in holding the government to account. The Supreme Court was acutely aware of the political context. It emphasised that the case was a one-off. However, it was a court. It had to confront a situation in which, in a particularly acute way, the erosion of the conventional part of the Constitution meant it had to choose between finding that one had hit the bedrock of law in the constitutional order, which the court had a role to enforce, or finding that there was no effective control at all. I was a party to the decision, and obviously I think it was right, but I do not think it is a harbinger of a more general move to unjustified judicial activism in the extension of legal norms regarding control of the executive. I would emphasize 2 points about it. One is the extremity of the claim being presented by the government. That is, that on the first day of a new parliament, the government could require the monarch to prorogue it and keep it out of action indefinitely, involving an absolutely fundamental breach of the constitutional principles regarding the role of parliament. The fact that the government adduced no evidence to justify what it had done served to emphasize the extremity of the claim. The second is the time-critical nature of what was at stake. The UK was negotiating and seeking to finalize a new treaty with the EU, which would have profound political, economic, and constitutional implications for the UK. This was a matter which Parliament had actively been reviewing, and in relation to which it was seeking to exercise a measure of control over what the government was doing. This would seem to be a matter in which the principles of parliamentary sovereignty and of the accountability of government to Parliament were engaged in a particularly direct and powerful way. Disablement of Parliament at such a juncture would have undermined them fatally. So I conclude both this lecture and the series. Robert Crowcroft argues that an important component of British national identity is constitutional, in that for many citizens, Parliament represents the epicenter of the lawful social order. However, there is plenty of commentary to the effect that respect for politicians and for the political order has declined. As I mentioned in my first lecture, in order for the Constitution to command public acceptance and underpin consent for the government's rule, there has to be a degree of emotional loyalty to it. In the 18th and 19th centuries, there was a powerful narrative surrounding the British Constitution as a constitution of freedom. The historian J.G.A. Pocock draws attention to the link between historiography and sovereignty. Definitions of historiography have a political dimension. I quote, "They presuppose that one of the aims of the state is to exercise some control over its own history, defining its past, and seeking to determine its future, that the liberal state associates individuals within it in this enterprise, that of seeking the freedom to act as citizens in the determination of their own historicized identities, that political sovereignty was so far the state's means of prescribing its historic past and future, that it was doubtful whether the individual could be accounted free unless a citizen of an autonomous and sovereign political community," end quote. Maurizio Veroli argues that a constitution should be sustained by a patriotic sense of the value it has demonstrated over time and the freedom it has sustained and still sustains for its citizens. There is a limit to how far the courts can contribute to this beyond their day-to-day practice of giving effect to proper standards of governmental behavior in accordance with constitutional values. But they should be sure to remind the readers of their judgments that the UK Constitution gives expression to an ethic of freedom of the individual and of the nation. The motifs of a liberal democracy are freedom, solidarity, and hope. Freedom is the freedom of self-determination in its individual and collective aspects, both of which are important for the legitimacy of the regime. A sense of solidarity is necessary to constitute the demos and to allow for effective collective decision-making, while at the same time promoting respect between citizens with conflicting views and ensuring that they are accorded political equality and protection. Hope, in the shape of the possibility of changing hostile political opinions and outcomes today to positive opinions and outcomes in the future, is necessary to bind citizens into the political regime. The constitutional order has to give effect to these values and find ways of giving expression to them. In that way, the Constitution can be a focus for public loyalty. Thank you.